The tract says, hit the like.
Greetings and welcome to Classifications of Property, Distinguishing Rights, Interests, and Attributes. But before we get started, just to remind everyone, this is strictly for the educational entertainment purposes of this YouTube channel and broadcast, not to be used, misconstrued, abused, or misused for anything legal, lawful, personal, private, public, tax, financial, or otherwise. So whatever you do, please don't do this at home. Let's see here. That said, let's get started. Okay, here we go. All right. So we're on to the legal classifications of property and distinguishing the rights, interests, and the physical attributes. So we were working on property and the whole principles of property, ways a bundle of rights, but I found that we need to go over these foundational attributes first and find out exactly what classifications and attributes, what all these lines of discernment are between the way we regard property in that bundle of rights that is recognized by law as property rights. So let's really break this down here. So before we can be classifying these property rights or property law by legal status, one must distinguish a property's physical nature. These attributes apply to both real and personal property. So we have corporeal and incorporeal. Corporeal, synonymous with tangible. Incorporeal is synonymous with intangible for most cases, practically. I'd say that they're pretty much interchangeable, and I think depending on the context you're in, one may be preferred. So corporeal means literally has a physical body. It can be touched, seen, and felt. Here are some real examples like land and soil, buildings, and structures. Those are real, you can touch them or see them. And then there's personal examples like furniture, goods, utensils, money, and physical objects. So real, these are legal terminology, and personal. So the real examples include things like soil and land as property, and buildings and structures, which are immovable. And then we have incorporeal, the intangible. These are rights with no physical substance. They're often evidenced by documents, but the right itself is intangible, so it cannot be touched, seen, or felt. Here are some of the real examples relating to the property, is usually what we mean here by real. The right to collect rents is an intangible real property. And profit prendre, easements also are intangible. Access to the easements as intangible real property or incorporeal. So the profit of prandra is rights like the mineral rights or to get lumber from land, that type of thing. It's a contract basically or a lease, so it's an intangible. They're rights with no physical substance, often evidenced by a document. And then there's personal examples which we are more familiar with, like stocks, bonds, and shows in action. And we're going to get into this. Matter of fact, I think this is worthy of a good deep dive, and we like to do that by going to our Black's Law 9th edition. I believe that's what we got here. Let's zoom in a little bit more so we can see it better. Yeah, so we're on the 9th edition here, and let's find out about this shows in action. All right, here, show choice. Here we go. Okay, shows. Shows. I think that's shows. That's from French, that's why it's pronounced strangely. So instead of chose, it's shows. And it's a noun, French from the 17th century. A thing, whether tangible or intangible. A personal article, a chattel. See thing. All right, so before we could go any further, I think we have to take the advice and see thing, because we're not talking about just a thing. We're talking about the term thing. So let's find out what a thing is. Oh boy, that's before the 12th century. The subject matter of a right, whether it is a material object or not. Any subject matter of ownership within the sphere of proprietary or valuable rights. That's a thing. The subject matter of a right, whether it's a material object or not. Any subject matter of ownership within the sphere of proprietary or valuable rights. Valuable, putting a value on it. That's money value typically. Or proprietary, with ownership. These things, so things are divided into 3 categories. Did you know there were 3 categories of things? There is 1, things real or immovable, such as land, tenements, and hereditaments, which we're going to be covering. 2, things personal or movable, such as goods and chattels. And 3, things having both real and personal characteristics, such as a title deed and a tenancy for a term. So we had 3 categories: immovable, movable, and having both real and personal characteristics. So some kind of hybrid here. The civil law divides things into corporeal and incorporeal. All right, so there it is. We have all kinds of things. Corporeal thing, the subject matter of corporeal ownership, a material object, also termed res corporalis, tangible thing. And immovable things, see immovable, but we could go on for that, but we need to get back to where we were, which was shows. So now that we know what a thing is, we can understand what shows is. So shows, a thing. So one of those things, whether tangible or intangible, so you have both kinds of categories, and I assume the hybrid too, since you have both kinds. A personal article, a chattel. See thing. And then we go on to see shows in action from the 17th century. It's a proprietary right in personam. So this is a personal right, a proprietary right in personam, such as a debt owed by another person, a share in a joint stock company, or a claim for damages in tort. So a shows in action could be just a claim for damages in tort, or a right in personam, such as a debt owed. These are cases, it seems like, or actions. 2, the right to bring an action to recover a debt, money, or thing. We're back to thing. What were the things? The three categories. All right, and 3, personal property that one person owns but another person possesses. The owner being able to regain possession through a lawsuit, also termed thing in action. So shows and things seem like they're interchangeable in a lot of ways here. Let's read on about the shows in action. Shows or thing in action is when the man hath cause or may bring an action for some duty due to him, as an action of debt. And because they are things whereof a man is not possessed, but for recovery of them is driven to his action, they are called things in action. Wow, that's where it comes from. The term shows in action has been in common use for a long time, but some doubts have been recently raised as to its precise meaning. I think this seems intentional, but I digress. A divisional court, however, has now given us the following definition. Well, so generous of the divisional court. Shows in action is a known legal expression used to describe all personal rights of property which can only be claimed or enforced by action and not taking physical possession. Then here's the case. Okay, the phrase rights of property does not seem a very happy one, but it is quite clear that the court meant to include under the term shows in action rights under a contract and rights of action arising from breach of contract. So we see the intersection between contract law here and property rights and property law. So as you see here, we have shows in possession, the personal property for which title and possession unite in the same person, also termed thing in possession. So as you see here, thing can be slipped in very cleverly in a lot of as a term without necessarily disclosing it's a term, and unless it's recognized as such or questioned, it would just it would be accepted that everybody agrees to its meaning. So thing, 3 kinds, 3 categories. Let's just revisit the thing one more time here, so everyone's clear. It's from the 12th century. So quite an archaic word here, but not. It's just old. The subject matter of a right, whether it's a material object or not. Then there's the 3 categories: real, personal, and real impersonal. All right, I think we've dug deep enough into things and shows in action. Let's get back to the presentation. Okay, so we see here that personal examples are stocks, bonds, and shows is in action. So in this case here, we see that if it's a personal action to collect a debt or some kind of a tort, that it would be considered intangible property. They're rights, but there's no physical substance, and it's often evidenced by documents. But the right itself is intangible, and that's shown by the action that's has standing in a court. All right, let's move along. And this is a brief presentation, and we're going to have a very special surprise at the end, so make sure you stick around. I think we got through the thickest part already. Here's a concept of legal interest: freehold versus leasehold. Property law governs the rights associated with property, known as the interest. The distinction between indefinite and temporary interests dictates legal classification. So there's freehold, which has an indefinite. Not sure you say infinite, it's indefinite, meaning we don't know. But that's indefinite, so that goes out to theoretically perhaps infinity at this moment in time, but it's still indefinite. Then there's a leasehold, which has a fixed term. There's a defined end date, so we know where that property interest will cease. So with freehold, the definition: ownership interest of indefinite duration, absolute dominion over land. The classification, they call it real property. And a note: a freehold estate is required for tenements. We're going to be getting to that shortly. Now let's look at leasehold. The definition is it's a temporary interest in land for a fixed term. It's created by a lease agreement. And we have a classification here as personal property or chattel real. So it's not a tenement, it's a chattel real when you have a leasehold. If it's a freehold, it may be a tenement. So let's continue with these distinctions with real property. The immovable estate. Real property is lands, tenements, and hereditaments. We'll see this language a lot. Assets that are permanent, fixed, and immovable, typically requiring a freehold interest. So the assets that are fixed and immovable will require a freehold interest. So let's look at this more deeply here. We have the physical nature. Typically corporeal, physical land, buildings, but can include incorporeal rights like hereditaments, such as rents or riparian rights, which I think is, if I'm not mistaken, that has something to do with fishing or something. Let's see here if I can pull that up real quick. My memory's failing me on that one. There's this riparian situated on the banks of the river. Riparian, okay, yeah. It's relating to the wetlands adjacent to rivers and streams. And then there's a key distinction here. Immovable means it's fixed to the earth. Personal property is movable or intangible. A freehold interest separates real from chattel real. So chattel real and real property are differentiated by that freehold interest. If there's a freehold interest, that means it's real property as opposed to a leasehold or something, which would be chattel real. Then there's examples. Land, building, fixtures, condominiums, unsevered crops or trees. See now, like Christmas trees on a Christmas tree farm, if you're growing the trees on someone else's land and you have a lease, even though those trees are connected to the land, then that's still the leaseholder's property, but only for that term. And then there's gas, oil, while in the earth. All right, from the center of the earth to the heavens above. Now let's look at tenements. These are the permanent subjects of ownership. A tenement is everything of a permanent nature subject to a freehold interest. So the freehold is the indefinite ownership, not limited by a date like a leasehold. And in American usage, it's applied to almost exclusively to physical land and structures. An American usage. And this is something that I think is very special here in America, and with our American jurisprudence, recognizing this is one of the essential, the most valuable part of our property rights in a lot of ways. Before we go any further, just remind everyone that I believe we do have the talking chat enabled, so if you put something in the chat, it should talk it back.
The crime says, hit the like.
Yes, indeed. And then we can address any questions, comments, or clarifications, anything you want to add. Good time to do it now. We want to keep this interactive, so invite all kinds of conversation. Let's continue. So with tenements, we have a permanence requirement, so that indefinite period, right? A tenement must be permanent in nature. It refers to the physical durable structure or subject of the real property interest, not a temporary right. So the physical durable subject of the real property. Yeah, I guess dirt's durable too, right? Not a temporary right. A freehold requirement for the tenement must be associated with a freehold estate. A leasehold, term of years, is temporary and therefore is not a tenement. It is a chattel real. So here are some examples. A house or a dwelling, these are tenements. A building structure. A physical land partial, and permanent fixtures on land. So this is our tenements versus hereditaments. Tenements focus on the permanent subject. Hereditaments focus on inheritability and include incorporeal rights. So we have incorporeal rights that are included with hereditaments, whereas tenements focus on the permanent subject, the physical structures here, right? The physical subject. All right, we're on to hereditaments now, the inheritable right. Hereditaments are anything capable of being inherited, the most comprehensive term of real property. Unlike tenements, hereditaments explicitly include incorporeal rights. So we have hereditaments, have corporeal rights, the tangible, land and soil, the physical structures, and the natural resources in situ. So in situ is in the place, like see a lot of times the situs or the place of the crime, but this is on the place, the natural resources that are there. And then we have incorporeal or the intangible rights that come along with the hereditaments. Examples are the franchise, like government granted privilege. Example given here is utility operation, the profita prandra, the right to enter and remove minerals or timber. Then there's rents, right to collect rent from land, and the riparian rights, the right to use the water adjacent to the land. So all these rights here, you don't have rights to the water. You have rights to use that water because you can't own the water, I guess. But the whole point is that the hereditaments come with both of these. There's anything capable of being inherited and the most comprehensive. So they explicitly include all of these incorporeal rights here. Now here's our scope note that the hereditaments is the broadest real property term. Remember that. Hereditaments is the broadest real property term. Technically, it can embrace personal property capable of inheritance, but its primary domain is real property rights passed to heirs. Now we're on to personal property, the movable and the intangible. Personal property is all objects and rights capable of ownership, except freehold estates and land. Except the freehold estates and land. All objects and rights capable of ownership, except. So it encompasses both tangible goods and abstract rights, the intangibles. So here's the nature of this. We have the corporeal or incorporeal, the nature of your personal property. Unlike real property, which is primarily corporeal, except in hereditaments, which we have a little bit of both. Personal property spans both tangible goods and abstract rights, shares, bonds, chooses in action, and goodwill. And goodwill, wow. Here's a key distinction versus chattels. Personal property is broader. It includes intangibles. Okay. Chooses in action, stocks, partnership interests, which chattels and movables exclude. So the movable properties exclude these intangibles. And that's the distinction between personal property, which is broader, and chattel would be a subset of that. Here's a contextual example. Cooperative apartments. Oh boy. A co-op resident owns shares in a corporation. Now that's personal property. Remember, shares, stocks, bonds, partnership interests, which is an intangible asset, interest, rather than the physical unit itself. The corporation holds the real property. The resident holds stock. Wow. So let's look at some examples here. We have goods and chattels, corporeal, tangible, movable items. Those are goods and chattels. So tangible, movable. Then we have stocks and bonds. They're incorporeal, intangible securities. Another term. Okay, then we have chooses in action, which are incorporeal. They're rights enforced by suits. That's the action. And we have money, which is corporeal. It's physical currency. Interesting here, it's physical currency. But is it really corporeal? I guess in the case of property, if it is physical currency, it would be, but I think money goes a bit broader than that because a lot of currency is based on, uh, I guess you would say, documented evidence that it's there, but it doesn't physically exist. So is it really corporeal when you have an account number and a quantity assigned to it? Interesting. And then we have partnership interests, which are incorporeal, like contractual rights. So those are incorporeal, these partnership interests in the stocks, like the co-op example. And co-op shares, again, incorporeal, corporate shares. Now we're on to chattels and movables, tangible personal assets. We have chattels, which are personal property, and chattels personal. That's the items of personal property that are visible, tangible, and movable. So as we said, chattels is a subset of personal property. We could just say it's chattels personnel. Items of personal property that are visible, tangible, and movable. So chattel. Distinct from freeholds and leaseholds. Excludes intangibles such as uses in actions and securities. So those are not chattels, personal. And then we have movables. Those are things capable of being carried from one place to another without loss of identity. Not all personal property is movable. Unharvested crops are personal property, but not movables until severed. Wow. Okay, so there's a distinction right there. Whereas you think it's movable, yeah, but until it's separated, it's not movable. But it's it's personal property, but it's not movable until it's severed, and then it becomes movable. So let's look at this key distinction. Chattels emphasizes the tangible nature. Movables emphasizes transportability. Personal property is broader than both. So it could be personal property until it becomes transportable. Then it becomes a movable. So it includes tangibles, shoes, and intangibles, such as shoes and actions and stocks that neither chattels nor movables cover. So the bigger set is personal property, and within that we have chattels and movables. The difference being is that the chattels are the ones that are going to be visible and movable. Movables are things capable, but not all personal property is movable. So interesting here. Tangible is the essence with this, whereas the movables emphasize the transportability. Let's look at some.
Songbook says, "Hey folks, missed a few shows juggling two big jobs and playing with the court."
Oh, well, welcome and greetings, and glad you're here to join us. This is a short one, and we're just about to the best part here now. So we're going to go over some illustrative examples from a case law. Oh gosh, how'd that get in here? That's supposed to say coleslaw and statute. So we're going to look at some case authorities here. Chattels, furniture and ornaments, tangible goods and bricks that are pre-annexation. So the bricks before they're put onto the building are considered chattels and movables. But once they're on the building, those bricks become part of the structure and the immovable property. So again, just like the crops are unharvested or immovable until they're severed, the bricks are movable until they're set in a place and laid on into the building. Patents are chattels, but only sometimes, which is interesting. And boy, patent law is a can of worms we're not opening tonight. And then portable equipment, air conditioners, anything, a portable air conditioner, anything that's portable would be considered a chattel. And then we have movables, things like utensils, sinks, fans. Whoa, okay, portable AC units would be movables, and I guess you'd have central ACs would be chattels. And of course, copper tubing. I guess if you're a thief, it's movable. And small dog houses. And I wonder what the threshold is for doghouse size for it to be considered a movable or a chattel personnel. Well, a chattel would be movable too. But you can see here, these are just examples from statutes and some case holdings. So it's just some interesting way to see how this is juggled here. But there's not a very easy distinction, I should say, The emphasis here is that you want to look at what is being intended by putting a label on something. So if you're emphasizing the tangible nature of the property, you'd use chattel. If you're emphasizing the transportability nature of the property, then you would use movables. So they're both personal property. Which one you choose to label it here, depending on these different situations and scenarios, that's why the flexibility is there. Now we have chattel real.
Joseph figure 5227 says excellent study.
Well, thanks. This is we're taking a deep dive in a property, and it's just getting started. Bit off a little more than I thought we should be chewing there in the first stab at this. So we're going to break it down to some of these classifications and terminology first, and then we're going to go back to American jurisprudence and really break it down because there's some real gems hidden in there that I think everybody needs to know. All right, let's go on with the chattel real here, which is an interest in real estate that is less than a freehold, typically a leasehold, and classified as personal property, a hybrid straddling both worlds. We saw the chattel reals, that temporary interest in real property. So it's the subject matter is real estate, but because it's not a freehold, it's classified as personal property. So you see here the fixed term for the chattel real. You have a lease end. There's a lease start and a lease end. Versus real property is classified as personal property, not realty, because the interest, the interest is temporary, not a freehold. Versus chattel personal. So chattel real versus chattel's personal, as we saw there with the tangible items. It concerns an interest in land, which is immovable. Chattel's personal are tangible goods that have no connection to land. And versus the tenements. Not a tenement, which requires a freehold estate, as we saw before. Chattel real is, by definition, not a freehold interest. Key there. So chattel real is never a freehold interest. Here are some examples. Terms of years, leasehold. Long-term commercial lease agreement. Buildings erected on leased premises with removal agreements treated as personal until removed. A mobile home. All right, let's move along. So we get the synthesis here, the property classification matrix. So this is why it's so complicated, but I try to break it down here into a simple matrix. We have corporeal, tangible on this side, and incorporeal, intangible on this other axis. So again, these are typically synonymous, corporeal and tangible. Tangible and intangible are more colloquial, so people are more familiar with those terms, but they could be interchanged. And a lot of times these terms are thrown in like thing, just to make it a little bit more difficult for the lay people to be able to participate in our justice system. But I digress there. So let's look at real property. In the tangible side, we have the tenements. This is strictly tangible: the land, the soil, the buildings, the permanent structures and fixtures. Condominiums are real property. Then we have hereditaments, which have elements of both here. They have the franchises, which could be government privileges. Profita prondra, which is mining, timber, and rents and riparian water rights. So real property, being able to have these different characteristics, rights associated with them. So as tenements, if it's a tenement, it applies to things like the land, the soil, and the permanent structures. And the hereditaments apply to other types of rights that are intangible that apply to the land, to the tenement. And it's things like the rights for inheritance and rights to be able to lease out mining and timber. So these are the hereditaments, the incorporeal or the intangible rights associated with real property. So we also have personal property. So these are the two big categories: real property, the full tangible sides, and the ones that are even broader that include intangible rights. or interest. And then we have personal property. On the tangible side, we have chattels, personal, and movables. So sometimes just called chattels, but chattels personal to be specific, and movables. Things like furniture, goods, utensils, portable equipment, vehicles, money, and physical currency. Notice how these are two different things. And then we go on to intangibles and the chattel real. These are the other axis of personal property here. We have things like stocks and bonds, shoes as an action, goodwill, and the right of publicity. This is interesting. And leasehold, chattel real. Like goodwill is intangible, and chattel real, partnership and co-op interests. So the co-op interest, shares in a co-op, is intangible and chattel real. You never own the buildings or the industries, you own shares, which is intangible. And goodwill, again, is an intangible property. Interesting. And I think you could value this as something like social capital, which intellectual capital, but I think that deserves its own deep dive and beyond the scope of this presentation, which takes us to the best part here, which is where we're going to take the fun quiz here and test your knowledge. So here's how we play this game. In the chat, you put in the number of the question you're answering. So for this example, we'd have question 1. You put the Arabic number 1 in the chat, and then the letter of your choice. If I was choosing D, I put D delta, and that would be my choice. If I decided to change it, I would just put in that question number again, followed by my different choice, and that would be the final answer. We're going to tally up when we're done, and then test our knowledge. Here we go. First question. A utility company is granted the exclusive right to operate power lines across private land. Under property law, this right is best classified as A, a tenement, because it is permanently attached to the land. So they're granted the exclusive right. We're not worried about how. But this utility company granted exclusive right to operate power lines across private land. Exclusive right. Okay, this right is best classified as a tenement because it is permanently attached to the land, a chattel real because it is a temporary interest in the land, an incorporeal hereditament, a franchise, a government's granted privilege over land, or a movable because the power lines themselves can be relocated. Now, this is a tricky one here. And let's think about this here. A tenement means that there's a freehold, right? A chattel real is intangible. Element.
Auditum says 1C.
Okay, we get an answer here for 1C. Anyone else wants to take a stab at question 1? So you're choosing an incorporeal hereditament, the franchise, the government granted privilege over land. All right, let's move on to question 2. Mark assigns a 30-year.
Frog says 1A.
All right, so we have a 1A. Let's go back to.
Paper Dolls World 101 says 1A.
I'm going too fast, and let's go back to question 1 and look at A. We're looking at it as a tenement because it is permanently attached to land. We're saying it's granted exclusive right. So grantor granted exclusive right to operate power lines. All right, let's move on. We're going to find out soon. Mark assigns a 30-year commercial lease. Oops, let's get rid of that. Then rebuilds a burned structure under a removal agreement. The rebuilt building is classified as. Okay, so look at this. He signed a 30-year commercial lease, but then he rebuilds a burned structure under a removal agreement. Woohoo boy, just to make it complicated. The rebuilt building is classified as A, real property because it's permanently fixed to the earth. B, a tenement because structures are always freehold interests. C, personal property, chattel real, because a leasehold interest is treated as personality until removed. So the tangible part here, chattel real on property, that's, I guess, movable, right? A leasehold interest treated as personality until removed. And or D, an incorporeal hereditament, because it involves a right over land. Oof. So we got a lot of different choices here for a very confusing situation. Marcus signs a 30-year commercial lease, and then he rebuilds. To make it confusing, he
Joseph
rebuilds.
figure 5227 says 2D.
All right, we got one for 2D. An incorporeal hereditament, because it involves a right over the land. All right, so he rebuilds a burned structure under a removal agreement.
Sogdog says 1A. Sogdog says 2A.
All right, so we have a 1A and a 2A. Excellent. Okay. I think he had a 1A earlier too. Yes, indeed. Yeah, had to reduce the censorship throttle on the YouTube channel because it was starting to ban people when they'd select 2A or 1A. I was thinking you're talking about.
Audit term says 2A.
Yeah, thinking about they're talking about our Bill of Rights here, but indeed we're not. Okay.
Craig 3D3T says no idea.
Good. Well, at least you're paying attention because this is difficult. I'm trying to make it as difficult as possible. Last one was too easy. Okay, so we got 2A, real property, because it's permanently fixed to the earth. All right, good. Let's move along. We're on to question 3. Which scenario correctly identifies a movable and explains why the paired item is not one? All right, so to make it even harder, we're going to give scenarios. One is going to correctly identify a movable and explains why the paired item is not one.
Debonaridad says 2A.
All right, you got a 2A2. Excellent. And greetings to you, Divine Writer. Oh, and thank you for joining the membership. We're going to be doing some open panel live streams. As soon as I get some response on a post saying that people will be there, and we'll set up a good topic that will be open for discussion. All right, so let's look here. Which scenario correctly identifies a movable and explains why the paired item is not one? So, a bolted wall sconce, which is movable, and a portable floor fan, which is not movable. It is a tenement. So, one's movable, the other one's not. Which one correctly identifies and explains properly why the other one isn't? So, this one here, A, a bolted wall sconce. Okay, and let me give you guys, just so everyone knows what that is. A sconce is like the old candle holders that were attached to the wall with an ornamental bracket. We don't see too many of those anymore, but it's bolted onto the wall. It's movable though. And the second pair here is a portable.
Sogdog says 3C.
Okay. So you're reading faster than me. I'm just going to read through these quick while you all keep answering on this one here. B, a portable AC unit, which is movable. An unharvested apple orchard, not movable. Unsevered personal property. Wow. Okay, and we have C, a stock certificate, which is movable. A building, which is not movable. It is fixed to the land, making it real property. And D, copper tubing, which is movable, or a lease agreement, which is not movable. It is an incorporeal hereditament. So the copper tubing, which is movable, especially for those thrifty thieves there, or at least, and then the pair is the lease agreement, which is not movable. It is an incorporeal hereditament. All right, so we got some pretty good selections here. Let's go on to question 4. Question 4. Sophia owns a unit in a co-op apartment building. Diego owns a condominium. Which statement best distinguishes their ownership interest? A, both hold real property. The difference is only management structure. B, Sophia, who has unit co-op, owns personal property, corporate shares. Diego holds real property, a freehold in the unit itself. C. Sophia holds a chattel real. Diego holds an incorporeal hereditament. Or D. Both hold personal property. Residential units cannot qualify as real property. All right, this is an easy one. Anyone have take a stab at question 4? So we got question 4 going once, going twice, going 3 times. We're going to the final slide now and get the answer key. Okay, so here's our answer key. For question 1, the utility company is granted right to operate the power lines across private land. The correct answer is C. An incorporeal hereditament.
Pepper Dolls World 101 says 3C.
3C? Okay, we got you down for 3C. Okay, now we're on to the answers here. For 1, the utility company gets the right to operate power lines across private land. Those are exclusive rights. Is C, an incorporeal hereditament, a franchise, a government's granted privilege over the land. A franchise is a classic incorporeal hereditament, an intangible, inheritable right granted by the state. It has no physical body, and it is not a freehold, chattel, real, or movable. So there it is. Now for question 2. Mark assigns the 30-year lease and he rebuilds the burned structure under a removal agreement. Correct answer is C. It's personal property, chattel real, a leasehold interest treated as personalty until removed. So the building's on a leased land with removal agreements. He had a removal agreement for the burned structure. He rebuilt that burned structure, but it still had a removal agreement. Those are chattel real. Interest in the land falling short of a freehold classified as personal property. So if he decides he wants to take his new building, he can. Or I guess he could burn it down and remove it since he had a removal agreement. All right, we're on to question 3. Which scenario correctly identifies a movable and explains why the paired item is not? And the correct answer is B, a portable AC unit, which is movable. In the unharvested.
Great 3T says this was a rough treat at the end.
Yeah, but you didn't participate, so you didn't have to it wasn't a hard pill to swallow. You get to learn from this, though. Either way, it's better to learn here on the Tribe channel than in real life, where property matters can be a little bit harder to deal with. So consider it a treat. That said, let's see on question 3 here. The portable AC unit, which is movable, and the unharvested apple orchard, which was B, which is not movable.
Debonair says 3C.
Yeah, well, 3 is B, though, because let's go back here and make sure I didn't get letters wrong or something like that. Yeah, 3B. So a stock certificate movable building is not movable. It's fixed to the land. But again, what if it was the building that had the contract like we saw there for removal? So this wasn't probably the ideal one here, but B is, because a portable AC unit is definitely movable, and an unharvested apple orchard, just like Christmas trees or anything else that's grown, it's a movable, but only after it's severed from the land. Until then, it's considered personal property, but not the movable type. So that was the distinction on that one for question 3. But yeah, B is the best answer on that, and that's what we're looking for. Movables must be transportable without loss of identity. So transferring stock, as losing identity, is probably not quite considered the movable in that sense. Unharvested crops are personal property, but not movables until severed. A lease is chattel real, not an incorporeal hereditament. All right, so we're on to question 4. Sophia owns a co-op, Diego owns a condo. What's the correct answer? Or is B, Sophia owns personal property, the corporate shares of that co-op. Diego owns real property, a freehold in the unit itself. Because there's an indefinite term of his ownership there. That's a freehold. Co-op residents own corporate shares, personal property. Condominium owners hold a freehold interest in their unit, which makes it real property. So, boy, this was a difficult one here. I won't make the next one so difficult because I know it could be discouraging at times, but these are, I learned a lot from this myself and in preparing this. So I guess you could say that there's always more to be learned when it comes to fundamental rights and things like property that seem they're every day and everyone has everything figured out with it. But what you start to find is something like just the word thing has deep meaning when it comes to property and property law. That said, what we went over today was just simple. Oh, still got this one here. Sorry about that, guys.
Debonaird says 4B.
There you go. Now's the time to change it. So, yeah, sorry about keeping that on the screen there. Sometimes I miss the sweep. Nonetheless, let's get to back to as we were saying here that we've gone over the classifications of property. What we're going to be going into is more definitions of these particular kinds to get even deeper into these distinctions because some of them might still be a bit confusing. As you see, there is a lot of blurring between them, and depending on the conditions and the timing at which we're viewing the same physical object, it could be, or the same piece of paper, but the classification can change depending on the conditions and the situation and scenario. So, with that said, I hope you enjoyed this little deep dive into the classifications of property. We're going to continue a couple more live streams on property as we dive into American jurisprudence and really get down and dirty where the rubber meets the road and see what it's all about and learn something that you probably never even knew you didn't know. With that said, thank you all for attending. Make sure you hit the bell notification and make sure, of course, you're subscribed so that will work and be here for the next live stream. And I hope to see you then. Peace out.